So wanted to welcome everyone to our Landlord webinar. We all survived April 1st, so congratulations on that. And we'll get into more on that topic in a second wise. So I want to introduce everyone here. So on your screen, we have Kyle DeVigi. He's a director of operations and realtor with Remax Wealth Builders Real Estate. He's going to be helping moderate the questions and answers, which you can either write your questions in the chat box or there is a question and answer section as well. So at the end of our talking, we'll go over your questions and answers on various topics. We want to really keep it to the whole topic of tenants that haven't been paying rent or didn't pay rent on April 1st, or maybe they've asked for a reduction, they had paid you now, but maybe they're concerned on May 1st. And what are your rights as a landlord wise and what you can do. So that's kind of what we'll focus in on. And then below we have Elaine Page, an award-winning paralegal, was awarded Paralegal of the Year by the Ontario Law Society, so we only bring you the best of the best here. She has amazing insight. So to start off with, I wanted to give you guys an idea of my what I have in my portfolio wise and what I've seen. So my portfolio is made up of 14 condos. We also own a triplex in High Park and an apartment building in Hamilton wise. So we have a large scope of what I personally own and what I see on the ground. So have some great experience just dealing with this personally wise, my own portfolio. We also own a property management company as well called Access Toronto Property Management. So April 1st was really interesting for us to see what was happening leading up to April 1st and what actually happened on April 1st. Out of all the properties we managed, we only actually had about 2 or 3 inquiries of tenants saying, you know, can we defer our rent or negotiate a reduced rent? So that was good because we do a great job in regards to screening individuals coming in. So we didn't get too many requests on that end. So overall, April 1st was an overall success for us. And surprisingly in Hamilton as well, where I thought I'd have the most trouble, we had no issues in Hamilton. We have the building's 12 units there and everyone actually paid. So that was good to see as well. So overall, April 1st went well. I did get calls from people on April 1st wise, some clients wise that have their own properties. And what our advice was is, you know, have a conversation with your tenant wise. You don't give in right away. Because a lot of people have heard things in the news. You want to ask them questions and understand what their situation is. And also say to them that you have costs associated as well. And really the bank hasn't deferred your mortgage on the property wise. So your costs continue to be the same. Obviously there's cases why, so I can give Kyle, for example, one of his investment properties, he has a bartender living in his property wise, obviously is not working wise. His tenant called him prior to April 1st, giving him, hey Kyle, what's up? I got laid off, I'm not making any money. And Kyle obviously knows that and he's sympathetic to the situation, and she paid on April 1st, didn't she?
Yes. Yeah.
Yeah. But he knows that this is someone who could be in a situation depending how long this is wise, and he will probably negotiate something with her coming up, that kind of thing, if there's an issue wise. But if you know the profile of the tenant wise and you're like, you're still working and that you're just using this as an opportunity to get a reduction in rent, that's where you got to ask the right questions and don't jump right away. You want to take a strong stance on this, ask direct questions, and don't let the tenant push you around. You want to push back just the right amount, but understanding the situation as well. Obviously, again, Kyle, if they're in the service industry with his unit, he knew there was going to be an issue, or if someone's in a flight attendant. You know that they're not working right now. So typically you really got to take it on a case by case basis wise when you're dealing with these situations. The other thing where individuals may be like, okay, well, maybe I'll just sell my unit. It is definitely not the time to sell your unit. We are in what I call the COVID void. It has crawled to a snail's pace in regards to our listings for sales wise. And you're going to have to sell it, again, another point, at a COVID discount right now if you wanted to sell your property wise. So it's really not the right time to consider selling your property. It's time to buckle down the hatches, speak. If the tenant comes to you, speak with them. But you don't want to be putting your property on the market right now for sales wise. It's actually, I would say, in about 2 weeks, probably a great time to buy something. Look at opportunities to buy wise, because there is that COVID discount out there, and there are people that are in situations where they need to sell. So it would be a good opportunity to look at some bargain buying opportunities wise, and look at getting a longer close on it potentially to get through the slower rental months, because the rental market has been impacted as well. So not on the sales side, but on the rental side, the rental market's soft. People are still renting, but you're not getting the rates that you were getting in 2019. There are still strategies that you can take because this is going to end and everything's going to go back and to normal. I predict in 2020, not 2020, in 2021. So I wouldn't, if you get a property, you don't want to have property vacant right now, but if you do have a vacant property, there are strategies in place to lease it out fairly quickly wise, and then recoup your costs in 2021. So if you have any questions on how to do that, you can reach out to me directly wise, and we can talk more about that. And I think that's a good preamble wise to get into, the reason why the rental market's soft and why it's continuing to be soft and why you don't want to sell now. Remember, the borders are closed. There is no immigration right now. Toronto benefits very greatly with immigration wise. The majority of immigrants that come to Canada wise end up in the greater Toronto area. There is no immigration right now. Borders are closed. Number two, and especially for the downtown Toronto market, your summer months are typically your busiest months of the year for rental wise leading up to September 1st. You have two things. You have all the new employment coming in, people looking for places to move into because they're starting new jobs. But number two, you have the whole international student population. And at any given time, the international student population in the greater Toronto area is over 100,000 individuals. Again, borders are closed. We don't know how long this will last, which will threaten the international student population for September 1st if we don't have that timeline met. So that typical influx of individuals that come over the summer months that will be hurt by this and is in danger if the international student population doesn't come to be hurt for, I would say, over the next 6-month period. So that's going to, again, depress rents over that period. You can recover in 2021, and there are strategies to do that. But it's not a time that you want to take a definite hardline stance with your tenant wise, because if they leave, then we could be in an empty unit wise and you have no revenue coming in. So something to keep in mind as well. And now I'll segue into Elaine, and Elaine can talk from her standpoint. If you get that message from the tenant wise going, can I have a rental reduction or a rental deferral? And very important, deferral wise, this is not a rent holiday, a rental deferral wise, how you handle these conversations. So Elaine, why don't you start off by giving us some of your background?
Thank you, Alex. So hi, everybody. My name's Elaine Page. I'm not Ellen Page, but I get called that quite a bit these days. And I am what's known as a licensed paralegal. I'm licensed with the Law Society of Ontario. And just quickly to let you know, because many of you don't know, that Ontario is unique in the entire world. We are the only place that actually has licensed paralegals. So that means that we are licensed to practice in certain areas of law. And in that is landlord and tenant. And I will say that most of my colleagues that are practicing in landlord and tenant are in fact paralegals. They're the ones who have the most experience. So I just wanted to let you know that, because we still, even though we've been licensed since 2008, the world still doesn't know about us. So we're an alternative and cheaper option for legal services.
And I'll jump in there. You know, people's immediate response may be like, "Oh, I'm having an issue with my tenant. Let me speak to my lawyer." It is not lawyers you speak to at all. It is the paralegals that are on the ground that do handle all of these situations wise. So it is a paralegal you want to reach out to when you're dealing with these landlord and tenant issues. It's not a lawyer. They do not have they don't have a lot of experience dealing with these kind of things. So just wanted to jump in there.
Thanks, Alex. Yeah, so I've been doing this prior to regulation. Regulation happened in 2008, and I've been doing this for almost 30 years now. So it's had various different formats, court and tribunals and what have you, but this is my primary area of practice. So Alex was asking about rent deferrals and rent reductions. So I firstly want to just talk about rent reductions for a moment, because over the last week I've been getting calls from tenants who are in condos who no longer have access to the swimming pool and the gym and what other common areas that the condo has, and they're asking for rent reductions because it's a reduction in service. And my flat out answer is no. Under normal circumstances, if you had use of a pool and you don't, then you would get a rent reduction. But in this scenario, no, I don't believe, I could be proven wrong, but I don't believe you're entitled to a reduction. So coming down to rent, I mean, I've been fielding calls and doing agreements all week. Really, the idea is to show some compassion and kindness to the tenants. Most people are really in a high anxiety state, and if they think they're going to lose their housing, that escalates it. So one of the things that I've been asking people who say to me that they have been laid off is to actually provide some evidence of it, as opposed to those who just want to take advantage of the situation. So once I get proof of that, and once I ask them if they qualify or eligible for any of the benefit packages and when will they be applying for them, most of them are telling me that they are eligible, they're applying, and they're hoping to have rent the money by about the 17th, 18th of April. And that's based on what the government is saying. So in those cases where I've had really good tenants all along, there's never been a problem, I'm saying to them, all right, we will hold off, but please contact me on the 18th and let me know where you're at. If they still have a problem on the 18th, then that's a different course of action. There are other ones who just have not, they have no means of paying, or they've been in arrears frequently. And with those ones, I actually am issuing out N4s. Those are notices of termination for non-payment of rent. And primarily the reason I'm doing that, and we'll talk a bit more about this later, is because the Landlord and Tenant Board, although they're not issuing orders for eviction at the moment, eventually they will. So I want to get the timelines running now. I don't want to wait until 3 months from now before I start, because we're going to have a massive problem if we do that.
And I'll jump in here as well. And Elaine and I were talking about this before, and I learn things every time I talk to Elaine. So when we're determining what we wanted to speak about today, we were talking about the process, who can sign the N form. So when I say the N forms, there are multiple forms, N4 is one of them, but there are other ones as well. And the only people that can sign one of the N forms to validate it is the owner of the unit or someone licensed with a law society, correct?
That's correct.
And why this is so important, how I know Elaine is I had to use her services myself. So when we bought the house that we live in, we live in the triplex that I referenced earlier wise, and it had 3 units, and all the units had existing tenants, and we relied on seller to provide notice to one of the tenants, and we were going to owner occupy that unit. Well, guess what happened? Notice wasn't properly served. They didn't fill out the forms correctly, and lo and behold, come closing date wise, the tenant was still there, and I couldn't move into the property, and Elaine had to jump in and negotiated with the tenant wise and was able to get us in there early wise. But why it's important, the worst case scenario for that situation was the whole restarting of the notice process wise. So we were potentially going to be homeless all the way into November, and we expected to move into the property at the beginning of August wise. So that starting that process is very important, and getting the forms done right. You can throw common sense out the window. You really have to hammer down that point. If the forms are filled out incorrect, it's called a fatal defect. Your I's literally have to be dotted and your T's literally have to be crossed correctly wise. Common sense does not apply. It's fully lettered in the law. If there's a mistake on the form, they throw it out and you start the whole process over again. It's very important to have the right individual professional wise doing that. So I'll let Elaine get
Yeah, thank you. Just one last piece on all of that. Well, 2. First of all, if you're a real estate agent and you're doing notices for your tenant or your landlords, and you screw it up, you actually have liability, and I'm not sure that your errors and omissions insurance would cover you. So it's a good reason for you not to be doing them. And the other thing is, I see lots of real estate agents at the landlord and tenant board all the time, and they are ceremoniously told that they are not allowed to appear there or that they don't have any standing because they're there for clients, and they're so just a caution. And that is across the board, across the province. So if it's okay with you, Alex, I want I want to talk about the N12s because I've been getting calls on those. Yeah.
So to explain to people, and I have it on my list here, what we're going to go into, can you evict a tenant for non-payment of rent or owner occupying a unit? The N12 involves the owner occupying of the unit. So these are the 2 typical eviction things. Either you're evicting someone for not paying rent or you want to occupy the unit. So that's what the N12 is. So go ahead, Elaine.
Okay. So the N12 is used for purchase and sale, where the purchaser requires the premises for their own use, or if you personally want the property for your own use. This N12, which is followed by what's called an L2 application, is the most abused notice, bar none. That, like, before we're in pandemic mode, this was the one that was abused the most, because a lot of people have rental units where they're under market and they're long-standing tenants and they want them out. So they'd say, okay, we're gonna say we're living there, and then they didn't. So this week I've been getting lots of calls from people saying, I want the premises back for myself because they were worried about the rent. And the reality is the bar for these sorts of applications is extremely high. You have to actually live in the unit. I don't mean just keep it empty. I don't mean just, store a pair of shoes there, but actually live in the unit for a period of 12 months. And you can't put it up for sale. You can't put it up for rent. And if you do any of those things, it is a finable offense. If you're a corporation, the fine is $100,000. If you're an individual, the fine is $25,000. And then that's just at the landlord and tenant board. Under provincial offenses, it's also an offense. So there's a secondary penalty you could have to pay, plus you would have to likely pay the tenant an extremely large amount of money. So for those of you who are thinking about an option of, I'm going to just say I want my tenant out because I want to move in there, it's not a good option for you. The second reason it's not a good option is because the board isn't issuing orders to terminate tenancies. So it's just not going to work for you. And I will also say to you that if you have the big smart ass idea that it's okay to illegally to lock out a tenant because they haven't paid rent and because you're frustrated and because you've got a mortgage and you want your property back, you're setting yourself up for again, it's totally a finable offense, and you will be hit, especially in the middle of a pandemic, with a huge, huge fine. So don't do it.
Yeah. So yeah, we were talking about before, avoid the vigilante justice wise, trying to take things into your own hands. Again, you're solving a short-term problem, but creating a bigger long-term one and creating a liability for yourself. So overall, we haven't really provided any, it's been more sobering news for anyone than positive news. And really where it comes into is, well, we'll get to this point later, but what it gets into is negotiating with the tenant, right? Dealing with the tenant, with the reductions and potential deferrals wise. And because it is such a stressful situation, you're a landlord, you have your costs wise. So you're under stress and you're worried about your job and your family, your asset and everything. And then you have a tenant who's under stress as well, and because they're worried about their income and everything along those lines. So you have two stressed parties, which is a ticking time bomb, and that little match can set everything off. Obviously, people can have those discussions with their tenants on their own, but if it's a high stress situation already, things can turn from manageable to bad really, really quickly, and then to worse. And remember, these assets that we have, and we focus in on condos wise, they're $500, $600, $700, $800, $900 million assets wise, and you have this individual living in there, and there's a lot of damage that they can do to the property if things go sour wise, and then it's a long road to try to recoup anything, even if that's possible. You have to go to small claims and everything like that. Usually ends up just being a write-off and moving on. So very difficult to recoup things when this stuff happens. So I would say when you're dealing with the situations, a mediator is important. So why don't you talk about, Elaine, what I mean by mediating, a middle party. Why don't you talk about how, we kind of talked about a little bit, but how you handle dealing with these new conversations that have started coming up since, I would say, the last weekend of March.
Sure, thanks. So there's two types of mediation. There's a mediation that I might do, and then there's official mediation at the board as well. And there are mediators at the board working. So I just want to separate the two, because that word.
Oh, yeah, I know what I mean by mediator. I just mean a middleman. So let's take the word mediator out because it can be confusing. Why don't we talk about being a
negotiator?
Yeah, a negotiator. You're the negotiator. You take.
So
and Elaine, because she's been doing this for 30 years, she has a great bullshit reader. So in regards to the question wise, like, how do I know my tenant's telling the truth? Elaine's heard every story in the book, so she can read through the bullshit. So pardon my French, everyone, but just that's exactly what it is. So Elaine, why don't you talk about that?
Yeah. So a lot of times people, let's start with landlords, they're really, really uncomfortable with negotiation. It's not something that they do on a regular basis, and they don't know how to do it. They're also highly, highly emotional. This is their asset. So they're not always in the best position to be negotiating in their interest. So what I do is I would speak to the landlord and say, okay, tell me what your situation is. What do you need? How do you maintain your asset? and I go through how long the tenant has been a tenant and whether or not they're a good tenant, whether there's been payment history problems. So I get a general feel for who I'm dealing with. And, I also want to know if the landlords have an awareness of illness on the tenant tab, or disabilities or anything of that nature. And then depending on the situation, I will either phone the tenant or I will send an email explaining who I am and that their landlord has asked me to get in touch with them to discuss the rent. And I take a soft approach initially, and I will ask a bunch of questions, and then I'll get instructions. I'll take it back to the landlord with some instructions, and then usually we can easily come to some kind of arrangement. I'll follow that up in writing with both parties so that they have they know what to expect. Part of the problem is that the board, when we do a mediated agreement, there are set timelines. You are going to pay by the 15th, and if you don't, without notice to you, we can evict you. We can't do that anymore because we don't know what our timelines are. We don't know when this is going to be over. So it's really, really important to establish good communication between the parties so that you can protect your asset and we can all come out of this with less stress and more success.
Yeah, very, very good points as well. And that's, I do think a middleman is very, very important in these situations because people have so much stress on their plates dealing with other things, and this will set someone off. And as I said, you want to have your tenant on side with you right now because it is not a great rental market out there, number one. Number two, don't sell. I don't want you to sell right now. It's not a good time to sell. So you'd be leaving, you'd have the COVID discount, you'd be selling it at a discount wise. So it's not the right time to sell the asset. So you work, if this comes up, you work with the tenant wise and you figure out a solution. And that's where, we'll go back to Elaine's bullshit reader, figuring out what the situation is with everyone like that. And she knows the right questions to ask.
So Alex,
yeah.
just to jump in, just to give you an example, I got a call at 8 o'clock this morning from a tenant who has money, who's working, not an issue, but she couldn't remember, she had run out of checks and she couldn't remember if she had left the landlord with the April 1st check because the landlord hadn't cashed it yet. And was all panicked, like seriously in panic. She's got money. This is somebody who's in a great position, got money, just didn't know. And I called her back right away and I said, we're looking into it. I'm not going to have an answer for you till Monday. Just relax. And the gratitude in that situation was extraordinary. And this is a woman who could pay her rent and there really wasn't an issue. So if you think about it from that perspective versus somebody who can't pay their rent, then the stress levels is it's extraordinary. Also something that you just said, I just want to jump on, Alex, around not selling now. Not only do I agree with you, but I would say that if you have tenants in your unit, it is virtually impossible to be able to do showings, and you're putting your tenants at risk.
Correct. It's not and on top of that, there are buildings in Toronto, no more showings. The building is not allowing visitors and not allowing real estate showings in the building wise. So beyond that, like selling it and selling a tenanted property right now, we talked about this last call. I can't guarantee, Elaine can't guarantee, Kyle can't guarantee if that tenant is going to leave once we sell the property. So then we hit the closing date of the property, tenant's still in there. Now we're in a complete disaster-wise. Tenant hasn't left, buyer's pissed off, seller's pissed off, tenant's pissed off. Now are there lawsuits coming? Because it's just an absolute disaster waiting to happen. We are really in the Wild West right now. And that's where experience really comes into play. Again, silver news, but we're all going to get through this. This is a short-term situation. So in a short-term situation, panic is the wrong thing to do. Common sense, prevails and how to tread through these rocky waters. And Elaine brought up another point. Because we are in a health crisis, something that she brought up to me and something she wants to bring up to you is about wills. So you wanted to talk about wills?
Yes, yes.
Tenants wise, but it's something important as well to touch on.
Right, thank you. So I will tell you, I'm not plugging anything here because under my license, I'm not allowed to do wills. So only a lawyer can do it for you. But it is a good time to really revisit that for yourselves, for your loved ones, and in particular, power of attorneys. And the reason why I say that is in Ontario, if you don't have a proper power of attorney for medical, and something happens to you and decisions need to be made, like you're on a respirator, for example, without a power of attorney, the Ontario government gets to make the call, which is really frightening. So I will tell you that you can go online and there are, we call them POAs online. There's wills online, don't use them. They're generally not very good. And if, especially the wills, they have been booted out of more courts, those wills, and contested more times than I can tell you. So it is a good time to get in touch with your lawyer and get this done, because unfortunately we're all in a terrible situation.
Yeah, and especially as if you all own additional real estate beyond your principal residences wise, doing an online will is going to be garbage wise. You need to have that expertise, especially if corporations and everything like that. So bringing it back on the positive side, even though you can't evict tenants for non-payment of rent, you can't evict tenants for moving into it, do not do vigilante justice wise. You may be sitting there going, well, what the heck can I do? And that's where it's just when the conversations come up, have the conversations. And if you're not comfortable having the conversations, you can bring someone in to have the conversation for you. And Elaine is someone that can have that conversation for you. And that's how we navigate these waters during these times. Again, I survived April 1st. All my money came in. The majority of our property management clients, all the money came in. And the people where the money, there were some issues wise, those situations resolved themselves, and everything was by having a conversation wise and knowing how to ask the right questions. And again, detecting bullshit, very important. A lot of bullshit out there right now, having a great bullshit meter. So I think what we'll do is we'll open it up to the questions wise. Kyle, why don't you go through the questions that we have sitting on the board right now?
Yeah, great. We've actually gotten quite a few. I think many of them have been answered, but I think it's good to just cover some of them if we did
sure.
already. So someone asks, and I think this is a very common situation right now, is the tenant is playing the victim here. They may not have lost their job. They're just trying to take advantage of the situation.
Yeah.
What can you do? Can you request employer documents, or what options are available?
So everyone who has come to me and said, I've been laid off, I've asked them for a copy of their ROE, and they have provided it to me. Record of employment, or in one case, it was a letter from the employer. So if you don't, there are people who are going to try to take advantage. Honestly, my experience over the last week is very few people that's not the norm. Most people are the exact opposite. But if you do find that, then serve them with a notice of termination.
You know what? And I have a great question here. I know I'm jumping over things, but it was in my list of things to talk about, and I didn't bring it up. You want to really overall avoid going to the landlord and tenant board. That's more of a thing of last. So this is Maxine Esses. It's really a last resort thing. So Elaine, why don't you talk about what the landlord and tenant board backlog was like before this all happened, and then you can really go into what you expect after it.
Okay, so since December of 2019, there has been a huge problem at the landlord and tenant board. there's a shortage of adjudicators and there's a shortage of staff. And I mean, you know, most of the adjudicators originally were appointed by the Wynne government. When their terms came up, the Ford government did not reappoint them, nor did they replace them. And apparently the process for replacing them is rather arduous. So ultimately what was happening and continues to happen is that there's a tremendous backlog. So for example, on those N12s where we're really relying on a termination, 60-day termination because the property's been sold, it's taken me 4 months just to get a hearing. I have a case in Barrie. The rent has been owing since September or October of 2019. Had all been well, I have a hearing in June. So the backlog has become a real problem. And now with all of this happening, I can't even imagine. I mean, my colleagues and I have been talking about it, and we're actually trying to push the board into doing some hearings by phone now, but not likely going to happen. So if I were to start an application today, and I can issue applications, I probably wouldn't get a hearing date until August or September. Best case.
So that's where communication is so key. And that's where it goes. And Elaine's already been experiencing these conversation-wise. For the most part, I'd say we're like 95% people are reasonable, 99% of people are reasonable in the situation. Would you say that?
Absolutely.
Yeah, you're going to have your bad apples. Can't get rid of those, but the majority of people are reasonable wise. So Kyle, I'll let you get back into the questions, but I just wanted to touch base on that.
Yeah, no, it's great. Thanks, Alex. So someone on here wrote that they recently did lose their job. They have no savings and no way to pay the rent. Do they still have to pay?
Yes. You still have the obligation to pay your rent. And if you're in that position, I would encourage you to immediately apply for any of the benefits of coming available with the federal government. You can't, just to clarify, you can't be evicted for non-payment in this time, but ultimately what will happen is you will owe all of that rent.
And you know, if the landlord chose, they could go to small claims court, and there is a legal obligation, and there's a way to go still seek that out if the landlord chooses to go. No, oh, I'm being corrected.
Okay, so sorry, and this is new and we haven't talked about it.
Yeah.
It used to be that, you know, a tenant would leave and there were arrears of rent owing, no order from the board, we take them to small claims court. The divisional court in December made a ruling, which is a crazy ruling, that since it arises out of a lease agreement, that the proper jurisdiction is the landlord tenant board, which has exclusive jurisdiction of all of the residential tenancies. The problem, of course, is that once a tenant vacates a unit, the landlord tenant board will not allow you to issue an application there. So right now, that is an undecided area of law. There have been a number of cases thrown out of the small claims court because of that. I will tell you that recently, the divisional court, which is an appeal court, made that decision, and now a new appeal has been filed at a higher level at the Court of Appeal. And it's not heard, so it's an undecided area of law. And then before all of this happened, Doug Ford was rolling out a new bill that also dealt with this issue. So it's a very gray area, and that's why I would encourage you, if you need to do the N4s, to do the N4s and keep it in the board.
Okay, there you go. So and that's why you bring the professional in. Yes, everyone is going to get Elaine's full contact details. You'll also get a full recording of this as well. This will all be emailed to you wise. So why don't we continue on with the questions?
Yeah, great. So if someone has notified you that they're not able to pay the rent, but you have post-dated checks for them, should you cash those, let them bounce as proof of non-payment?
No, the letter itself is proof. And again, you're just going to piss off. You're going to do two things. You're going to piss off the tenant. You're going to incur bank charges for no reason. They're going to incur bank charges for no reason. Work with them. That's the better way to do it.
Great.
Great. So Alex, maybe a question for you. Are there any services right now to help landlords pay the cost that they're incurring if their tenants aren't paying right now?
Yeah, you can go get a line of credit on the property, the asset was. So, actually, in BC, this is where information is very important. Yes, in BC, there is the government's providing $500 a month to renters wise, and I believe that's being paid directly to the landlords. But that's in BC, doesn't apply to Ontario. So the answer is the government isn't doing anything for landlords wise. But again, if you're having a cash flow issue, you could seek deferral on the investment property from the bank wise. Or you can look into your current assets as well and refinances and everything like that. But you could seek out a deferral on that. I just wanted to jump on a question here I saw from Daniel was, commercial, you can do whatever you want. If they haven't paid, lock the door. Commercial, this is residential, very, very regulated. Commercial wise, pure capitalist. You don't have the rent, lock the door. You're good.
With a bailiff, with the use of a bailiff and
there you go.
properly, you don't just go and lock the door. There's
Yeah.
a whole procedure that needs to happen around that. Again, not in my scope of practice, but contact a bailiff.
Yeah, there you go. Contact a bailiff on the commercial side, but you have much more control on it on the commercial side versus the residential side. So keep on going, Kyle.
We've gotten a lot of questions about deferring payments and how to structure those. Do you have any advice for people that know that they're not going to be able to get their full rent on how to structure those payments and make sure that they do receive full payment in due time?
I don't think there's anything, I don't think you can make sure of anything in this day and age, realistically. Depending on each situation is unique, but one of the things that I've been doing is doing agreements with people and an N4 at the same time, but letting them know that I'm doing that so that they don't freak out. And then when the time frame's up, I'm issuing an application, and that's the insurance policy so that if they don't live up to their obligations, that you actually have some recourse to issue and eventually get a hearing. I will tell you though that the board has discretion when it comes to arrears of rent under Section 83. And I can't imagine the board making any order to terminate a tenancy because somebody was not working during this time and couldn't pay their rent. They are going to put the tenants on payment plans. I guarantee it.
And here's what it comes down to. The payment plan wise, this is where it's important. Dot your I's, cross your T's. This is what Elaine's advising wise, because if you do all that, then there is a recourse that you can go through to hopefully collect the funds is ultimately what it is. But if you haven't done it all and just went to the landlord and tenant board saying this guy owes me money, it's not going to work out for you. You have to have everything done properly wise. And then ultimately you want to avoid the landlord and tenant board because it's going to be a mess when it was a mess before. And now just imagine what it's going to be like after this wise. So again, reasonable people having reasonable conversations is the best way to deal with all of this right now. And that is how you're going to come ahead with the minimum amount of stress.
Yeah, and Alex, I said this last week, and I'm just going to reiterate it. You sort of touched on it. This is your asset, and you have somebody in control of your assets. So if you piss off a tenant, then there's no reason for them to not smash your walls in and, start doing crazy stuff. So that's really an important reason to work with people.
Yep. Any more questions, Cal?
Yeah, lots. So people have been asking about notice. Needs to be in writing. Given the current environment, what options are available? Can they send in it via email? If it's an N4 or if it's just deferral payment plans, how should they be communicating with their tenants?
So there's a standard lease agreement for relatively new leases, and in there is something that there's a checkbox on whether or not you're allowed to serve documents by email, but I wouldn't serve an N4 by email anyways, even if that checkbox is there. So you certainly can communicate with your tenant by email, but you are able to serve an N4 notice using the mail, the regular mail, but you have to be mindful that when you serve a document by mail with a termination date, that you actually have to add on 5 days to that termination date in order to make it valid for mail.
Great.
I will also tell you, if you're entering into some kind of written agreement, there is, I think it's called DigiSign, where you can sign online. I mean, you guys in the real estate world.
Yeah. I thought the sign or DocuSign, that kind of thing. So you
Yeah.
can track it right back to the email wise.
Right.
Yeah, great.
So one person has had their tenant pay their rent for this month. Next month, it was the 60-day renewal period they were getting into. They've only still paid the partial rent. Can they refuse to renew the agreement at the end of that period and force them out at that time?
Absolutely not. And this is a common thinking of a lot of landlords, that once the lease is up, the tenant has to leave. No, in Ontario, lease agreements, once they're up, the tenant becomes automatically a month-to-month tenant. You can't evict them. So that would hold true whether it's, today in pandemic times or regular times.
Yep. And the only difference right now is that we've just lost the ability to go to the landlord and tenant board and evict. It will eventually open up again.
Yes, absolutely. Absolutely.
For those individuals that do get the true bad apple, get that professional tenant wise, there will be a recourse eventually wise. It's just been shut down right now. Someone asked it, Elaine, the topic I didn't want to talk about, but it's there.
I missed the question. Yes, an illegal activity. Okay. So the question is, if somebody is doing an illegal activity, or I'm going to extend it to impairing safety, can you evict them? And the answer is yes. Depending on what it is, I will tell you the bar generally for those types of applications are extremely high. There are very few that actually go through. It depends on the behavior. I've heard from a colleague today that there's going to be a special application in the next day or so at the landlord and tenant board for this scenario. So it's an emergency application scenario. But if you've got an illegal activity going on, you better be able to prove it. I mean, smoking dope in a unit is not an illegal activity. I'll give you.
Tell the story about the gun and the cow.
Yeah, I was just about to do that. So I have a property in Dartmouth, and my client has a property. And not that long ago, we did an eviction there. It was a gang-related situation. We had the OPP come in. They arrested the male tenant, both actually, the female and the male tenant, on gun charges, weapon charges, and drugs. And the female came back into the unit. They had turned off all the electricity, and they had a generator running the house. And the fire department shut them down. But when we went into the house to do the evictions with the police, there was a cow and a pig and chickens inside the property. So that's kind of the definition of illegal activity. Drug dealing is illegal, but it's hard to prove it. Prostitution is also illegal, but it's hard to prove it. So the bar is very, very high to cross that. So it really has to be illegal to go down that road. So Kyle, you want to continue on? Kyle, you're on mute. Yeah.
So Alex, what's the best way to structure leases right now? Because obviously it's not the best environment. The price you're not going to get is, as high as you may want. So can you structure it in a way where, say, there's a discount temporarily, or how would you recommend going about it?
This is my recommendation. Give a month free. So get a higher rate and give a month free. So that way, when it goes month to month, you're going to be at that higher rate. So that's for your properties that are under rent control. For properties that don't have rent control, so that's buildings after November 2018, you can just sign a lease at a reduced rate, and then in 1 year with no notice. Once a lease is expired and they go month to month, you can increase to the market rate. So non-rent controlled units, slash your price, get it rented out. You can increase it next year to market rates with 90 days notice. Or if it's a rent control unit, offer up a free month of rent, and then you're set at that higher rate still. Elaine, do you want to add anything on that?
Yeah, just please make sure you're using the standard
Yes, you
lease
have to,
agreement by the Ontario government. A lot of real estate agents are still using the AREA forms, and they're not the right forms.
Yeah, you have to, you by law, you have to have the standard lease agreement. So with all of our leases, you know, the AREA form is your offer form. So when you're renting it out, and then your standard lease has all the clauses you can't change in it. And that's how you'd structure it there. So it's really simple on how to do those things. Like, again, free month, rent controlled, or lower level, and then increase it if it's not rent controlled in a year. Oh, mute.
If someone isn't able to make up the full payments for their lease right now, can you take some of that money out of their last month's rent deposit?
You could. I mean, I don't love the idea of doing that. The last month's rent deposit is really for the last month the tenant is in the unit. I think if you're going to do that, make sure to paper it well, because what ends up happening is a tenant's there for 4 years. If they think they have a deposit and they don't, and they've forgotten, and then you've got to, revisit this and have a whole argument about it.
Great. So someone here has had a tenant who hasn't paid for several months already. However, the tenant was granted a stay of eviction on March 1st for an April 9th hearing. Can they push for the board to still keep this hearing via teleconference or written?
So I looked at that one. I looked at that question. That person who asked that question has their own representative. They should be talking to their own representative, but the answer is no, you cannot push the board because the board isn't having any hearings.
Great.
All right. So this is an interesting situation where someone has a tenant who is living with them and sharing personal spaces like the bathroom or kitchen. What can they do if they're still bringing guests over? And if that guest is then staying permanently and not paying any rent?
That's an exemption under the Residential Tenancies Act. The RTA does not apply. You can
Change the locks.
yeah, throw them out.
Throw them out. There you go. Yeah. If you're cohabitating and you're renting a room, that's the one instance where you have control.
So is there any advantage to structuring your leases like border agreements so that you can get around the rules? Or getting
No.
No getting around the rules.
Hard stop. No.
Yeah, no. We're both in agreement on that.
Good.
Disaster.
So someone here had an agreement that their tenant was going to be moving out at the end of March. Everything was amicable until now, where they've now said they're not going to leave and they're not going to pay rent. What do they do?
Okay, well, it depends. I get this all the time. People say I have an agreement. Really, it's a question of the nature of the agreement. Just because someone calls and says I'm leaving at the end of March, that's not a formal agreement. Unless it's an N11, which is or an N9. So an N9 is tenant's notice to vacate, and an N11 is agreement to terminate the tenancy. So I'm just talking about under normal circumstances. Unless there's those documents signed, we wouldn't be able to get an order to terminate the tenancy. In this case, the tenant isn't leaving, and there's pretty much nothing you can do because if they have an N11, then you could file an application at the board, but you're not going to get an order terminating the tenancy at the moment. Eventually you will, but you can also serve an N4 for non-payment. And that person who's asking that question, that's a very case-specific question, and I'm happy to address it with them personally.
Yeah, and again, Elaine, actually, Cal, can you put Elaine's info in the chat box just so people have it if they
Yep,
don't.
definitely. We'll send out an email after this as well with Elaine's information.
Okay.
Yep.
And is that all the questions? You got all these questions on the question. You got the question and answer tab, right?
Yeah, those are still active.
Oh, do we answer these are still all required to be
The
answered?
open ones are still open.
Oh, wow. Okay. Keep on going.
Yeah.
If
So how
they're-
about students? They may have a 1-year lease, but now they're going home because they have online courses. They don't need to be at school anymore. Does the situation change at all for them?
No, unless they're in residence, then no, they're still tenants under the RTA. It's the same for them as everyone else.
So Alex, what's the best way to screen tenants right now? Would you change anything? Given the
Take their temperature, sorry.
No, it's still standard practice. We have great screening. What we do is employment validation, credit check, and references, but references are basically useless. You just need the employment validation and credit check, and those are going to be the main things. In Ontario, you cannot collect more than last month's rent for a deposit wise. You can collect a small key deposit, if it's a reasonable amount. If it's a reasonable amount, that's all you can collect. So you're going to do the screening wise, and you're going to look at the individual, and that's basically what you're going to do. So there's nothing more that you can do unless you're making a decision based on the individual. Let's say they are in the service industry wise, maybe you don't feel you're concerned about their employment, something like that, but nothing really changes wise, just maybe asking in your head, thinking, okay, what will they be impacted by this, and will that impact their income?
Great.
I'm just seeing Alan wise, I just have to read the first answer. Hello, I've been 2 non-paying tenants, blah, blah, blah. That's when you got to get someone else involved. That's the key thing.
Yeah, and I will tell, that's the one about 2 tenants, and there's already an application at the board. That application is alive and well, and if you've done your N4s correctly, you're in queue to be heard, and serving a new N4 now would be problematic.
Okay. Tenant told me lost a job. Did background check, found still employed. Did it back? Yeah. So I guess if that's your bullshit reader, right? In regards to that, so just call them out on it. Is ultimately what it is. If they say they're unemployed but they're still employed. You didn't see the difference if you in N4 or in 3 months. Is there a difference if you issue it now or in 3 months? The N4?
Yes. The difference is if you do an N4 now and your N4 is up and you're able to issue an application, you're in queue now, which means you probably get a hearing date. I'm totally guessing, but August, September. If you wait 3 months, you're going to get a hearing date in December. And you're not going to have any rent between now and then.
All right, this is a rapid fire round. So they're not paying. Will this ruin their credit rating?
No, not if there's an order at the landlord and tenant board and the landlord sends it to the credit bureau, then yes, it will ruin their credit rating. Or it will, I don't know if it will ruin it, it'll show up on the bureau.
But that could take a year to get.
Yeah.
Can you take them to small claims court?
No.
We addressed that earlier. No, not right now. It changed in December.
Great. So someone took possession of a triplex prior to possession, deemed the property as not a legal triplex, and the person has to evict tenants to do renovations to bring it up to code.
Nope. Not right now.
Wait.
Nope. That's a very complex question.
Yeah.
So saying Doug Ford had said that Ontario tenants don't have to pay, is that still the case?
You always have to pay.
You always have to pay your rent. I think Doug Ford was trying to appease the masses, and really what he was saying is there'll be no eviction orders, but that doesn't mean that you don't have to pay your rent. It's a question of when.
Yes, Yogesh, yes, you can ask for the record of employment in case of job loss.
So if you need to refinance your property, normally an appraiser goes into the property. Can the tenant deny?
Appraisers are no longer going into tenanted properties. Don't have to worry about it. So I'll clarify that a little. Appraisers are not going to tenanted properties anymore. They will do desktop or drive-by appraisals. They may ask for pictures or anything. So the appraisers have changed their rules because the appraisers themselves do not want to go into the units. So you don't have to worry about an appraiser going into the unit.
Great. And what about tenants that are denying showings for, say, real estate or any other reasons? What do you do about that?
Nothing.
Yeah, we talked about that.
Nothing.
Okay, someone had a tenant who was in arrears since the very beginning. They'd worked out a payment plan to pay twice a month instead of at the beginning, but they're still delayed. What can they do?
So it depends on, you know, there's an agreement, but I don't know what that agreement is or what it looks like or how it was done.
And this is where if you're,
discrimination.
yeah, and if you're up against the wall, you know, call Elaine. Like if that's where what you think you've done and you think that you have validity, Elaine's the expert in this, and she can really help to change the situation for you. Okay, want to keep on going, Kyle?
Yep. So if some of the tenants don't want to acknowledge things in writing, like their loss of job, is there anything that you can do?
You know, again, it's status quo. If they're not being cooperative, then you have recourse through some of the things we've talked about already.
Yeah, and again, if you're up against the wall and you're struggling, call Elaine. That's the best bet.
For the
Send
next
me a
question
bottle
as
of
well,
scotch because I'm gonna need it.
if the tenant isn't answering, they've just gone dark, you know, what are your options? Call Elaine.
Yeah.
Great. So under normal conditions, how hard is it to evict a tenant from a basement suite if they're in your principal residence?
Depends on the reason for eviction. So that's a very complicated question, but just generally, you're bound by the act as to the types of the circumstances with which you can terminate a tenancy. And I don't like my tenants is not in the act. So, you know, every situation is different and we'd have to dive in a little deeper to know the answer to that.
And Alex, around rent control, can you give out the dates of when rent control applies for buildings?
November 2018.
Great.
There's
And
actually a specific date in November was, but November 2018, I'd have to look up the exact date.
And Elaine, for month-to-month tenancies, can they be terminated with 60 days notice?
No.
Outside of the pandemic?
Never. It was never like that before the pandemic. You could never, once a tenant signs a lease and moved into the property, they have a lifelong lease to the property, ultimately what it is.
Great.
And your only rental increases are either, if it's rent controlled, the prescribed provincial increases. If it's not rent controlled, then it's market rates.
Any special advice for short-term rentals, say Airbnbs that can no longer rent themselves out?
You should definitely not be doing Airbnbs in the time of a pandemic. And I don't know too many condos that allow them anyway. Are they licensed or not? That's a whole other kettle of fish.
Yeah. Month-to-month tenant. How do we increase the rent? You send the, here. What I would say though, right now is not the time to be increasing rent, to send rental increases. Wait till this is over and then send the rental increase. That's my advice, but it's, which form is it, the N to increase?
N1.
Yeah, N1 to increase. You do 90 days notice from the start of a rental period and make sure it's all correctly filled out and everything like that. But I strongly advise you doing any rental increases right now.
And I just want to jump in and say that if you don't know the basic rules of rental units, you're better off. And so some of these questions are, and I don't mean to be insulting, but they're very, very basic.
Mm-hmm.
I'm going to strongly recommend that you hire a property manager who knows this stuff. And I mean, Alex, that's your baby.
Yeah. No, it's
in such trouble if you don't know the rules.
And I'll jump in. You know, because I have my portfolio, my investment portfolio, and I get this question. People get concerned about tenants and everything. It's very easy, especially in the condo wise, to have investment properties and not run into any problems if you follow the right steps and do the right things. If you don't do those things, then you do open yourself to all the problems that you read about in the newspaper. But if you do the right steps, 99.9% of the time, you are not going to have issues. So I would agree with Elaine. If you don't know the easy things, and depending what you've done, you may have exposed yourself up to a lot of liability. Okay.
There have been a couple questions about people having rented out their primary residence. They weren't there, traveling, whatever. How do they get their house back now? What can they do?
Pray. It's an N12, and it depends on, did they rent them for a year? Did they rent them for a month? I'd have to see what they've done in order.
But ultimately, it's not your primary residence anymore. You rented it out.
Well, but if they've been traveling,
Yep.
and they now are coming,
Oh, of course, yeah.
Teaching positions in
Yeah.
Europe where that got, blown apart. They want to come back. So it's an N12.
But it's not enforceable right now, correct, Elaine?
Exactly.
Yeah, so yes, you can ultimately get back in there, but currently right now, you cannot evict anyone to own or occupy a property.
Right. So if a tenant stops paying rent, can you recover paralegal costs from them?
No. You can recover the application fees from the board. So an application, the cost of an application at the moment, it was actually supposed to go up on April 1st, but they suspended that, is $175. That becomes part of the application, the money that the tenant has to pay back, but my fees don't get unfortunately.
Mm-hmm.
And can landlords recover any of the outstanding rent amounts if the tenant refuses to pay?
Yes. Again, right now, as I explained before, we're in a very gray area around this issue. I would imagine resolution will come shortly on it and we'll have a more definitive answer.
So if your tenant currently has a lease, say in September, but they decided they no longer feel safe there and decide to leave now, is there anything you can do in that situation?
Ask them to clean the unit and leave it nice for you.
There's no way to enforce them to stay, right?
No.
Can you charge interest on any deferred rent amounts?
No.
Okay. The others are around Airbnb, so probably best to contact Elaine directly.
Yeah. Yep. Especially in those, especially Daniel, that situation wise. Yeah. Because and Daniel's, we've had in the past, we've run in that situation before, and yeah, so I would go directly to Elaine to help that specific case wise. And then Helen, answering that last question wise, renting out 3 months and renting out a year, both markets are soft right now. So I would just rent it out for the year wise and adjust your rent accordingly to get it rented out. It will rent out wise. You just have to adjust it accordingly. And then this will be the last question from Mary Ellen. Are we able to ask for bank statements from a tenant? You can ask for anything really, except other than a SIN number. Doesn't mean they're going to give it to you. They don't have to give it to you, ultimately what it is. So again, if you're having issues with your tenant and they're saying, I can't pay your rent, but you don't believe them and you're really in a communication issue wise, call Elaine. She can help you have those conversations with the tenants. So we've recorded this whole thing. It'll be posted onto our YouTube site shortly, and it'll also be emailed to you all as well to take a look at. Thanks for everyone for joining WISE, and we'll be doing this again on April 13th as we change, and who knows what new things the government may have for us, but looking forward to touching base with everyone then. Okay, thanks so much. Thank you, Elaine.
My pleasure. Thank you.
We have all our info up there. Kyle, can you just put her email up in there as well, quickly?
Yep, will do.
We're just going to put Elaine's information up in the chat box one more time for you. And again, you'll be emailed it all as well. So looking forward to speak with everyone, okay? Thanks, guys.
Thanks, everybody. Bye-bye.